Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, you know what? I'm the public defender. I have a right to be here, and I have a right to stand and represent.
Sit down.
From losing their temper to completely losing it, these are the times judges lost it in court.
As Newsom throws more paper at him, Judge Rimes single-handedly pins him onto the desk.
Number 1. Judge John Murphy attacks assistant public defender. Florida just keeps outdoing itself in the realm of outlawry. In Brevard County, a fight between a judge and an assistant public defender happened. The incident unfolded when Honorable Judge Murphy and Andrew Weinstock engaged in a heated argument during a court hearing, ultimately leading to a physical confrontation that required court deputies to intervene.
And resisting, you have the public defender. Public defender, what do you want to do?
They fought.
They have.
I'm not waving.
All right, what do you want to do?
What do you want to do? I'm not waiting. You want to set up for trial, set up for trial.
All right.
If you want to set for docket settling, set for docket settling. I'm not waiting in any case.
Tensions rose between the judge and Weinstock as they debated whether to waive the defendant's right to a speedy trial. Frustration boiled over, with Judge Murphy allegedly expressing his anger by stating,
"This is an emergency
if I
created
had
by
a
the
rock,
state.
I would throw it at you right now.
Stop
pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, you know what? I'm the public defender. I have a right to be here, and I have a right to stand and represent.
Sit down.
Weinstock, undeterred, firmly asserted his position as the public defender, asserting his right to be present and represent his client. This response appeared to further provoke the judge. Then the situation became increasingly tense as the judge allegedly provoked Weinstock by challenging him to settle the matter outside the courtroom, stating,
"If you want to fight, let's go out back and I'll just beat your ass."
The pair walked out of the courtroom into a back hallway where the fight took place beyond the view of security cameras. The sounds of the altercation, including loud thuds, were captured by the courtroom cameras while those remaining in the courtroom reacted uncomfortably and later applauded when the fight concluded. Blaise Trettes, Weinstock's supervisor and the public defender of the 18th Judicial Court, stated that Weinstock did not anticipate a physical altercation, but rather expected the conversation or argument to continue. However, there was no exchange of words before. Judge Murphy allegedly grabbed Weinstock by the collar and delivered several punches. Following the incident, Judge Murphy returned to the courtroom and resumed his rulings, remarking,
I will.
Despite the alarming nature of the incident, the judge was not arrested, and as at the time of this video, no criminal charges were pending. However, Trettes confirmed that his office would report the incident to the Florida bar, signaling the intention to bring attention to this incident within the legal community. The details of the actual altercation remain unsettling, and it is disheartening to witness such a confrontation unfold within the confines of a courtroom. The swift intervention of court deputies was necessary to restore order and diffuse the just when you thought you'd seen it all. Florida presents you with a courthouse clash that defies comprehension. Let's hope cooler heads prevail, and such astonishing incidents remain the exception rather than the norm. Number 2. Judge Elizabeth Shearer yells at Parkland shooter defense team. Brevard County Circuit Judge Elizabeth Shearer unleashed a scathing rebuke upon the defense team during Tuesday's sentencing hearing for Nicholas Cruz, the convicted Parkland shooter. As the proceedings resumed after a recess, Brevard County Public Defender Gordon Weeks voiced his concern to Shearer regarding some comments made towards Cruz's defense attorneys during the morning's victim impact statements. Weeks contended that these remarks were inciting violence, drawing objections from the prosecution. Shearer swiftly concurred with Weeks' observation, remarking, around 99% or a significant portion has been appropriate, while most have maintained decorum. There were a few comments that fell short. It's best to move forward rather than dwell on them.
They're testifying. Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
Weeks, however, believed he was witnessing a troubling escalation. He urged the court to take action and rein in the mounting momentum, ensuring it wouldn't resurface as a recurring theme. Assistant State Attorney Carolyn McCann vehemently refuted Weeks' claims, asserting there has been no encouragement or incitement, as Mr. Weeks wrongly suggested on the record. His statement is a blatant falsehood, distorting the facts. Chief Public Defender David Wheeler pressed Shearer further, seeking assurance that the court would prevent a recurrence of such behavior. He expressed his dismay over specific incidents involving the defense team, including offensive gestures and disrespectful behavior. Wheeler's frustration escalated when he believed his own children were targeted in the testimony. "I wasn't even aware you have children," Shearer retorted, clearly puzzled. "I have no idea what you're referring to."
I have no problems. I have thick skin. But once you bring in my children, I think that's highly improper.
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. And for this court to allow that kind of testimony is also
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely...
Wheeler asserted that Shearer would definitely take notice if her own children were mentioned in such a manner. "You need to sit down," Shearer sternly admonished him. "You've crossed the line. Go sit at the back with your chief public defender. He is the public defender," Wheeler retorted. "Mr. Weeks, kindly instruct your colleague to sit down and refrain from further remarks," Shearer instructed. "It is entirely inappropriate to threaten my children or raise such concerns. Go to the back of the room immediately."
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender. Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility.
Weeks then returned to the podium, attempting to engage Shearer in a conversation, but she swiftly shut him down. "Sit down, Mr. Weeks," she curtly commanded, denying him a recess to confer with his attorneys. Even as he walked away, Shearer continued to scold Weeks, ensuring her message hit home. "You have absolutely no right to send one of your assistants up here to make insinuations about my children," she admonished Weeks. "Now, please sit down. Your conduct is inappropriate and beyond acceptable bounds."
Did I ask you to go sidebar on this matter?
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing
I'm asking
you.
the
Go
court.
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
everyone
Your
in this
assistant just
courtroom-
did that. Go sit down.
No one in this courtroom had to endure what we had to
Go
endure.
sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're
Judge,
inappropriate and out of line. Go sit down.
Judge, may we have a brief recess?
No.
Number 3. In the Kyle Rittenhouse trial, Judge Schroeder loses it and yells at prosecutor. The courtroom was thrown into chaos as the judge presiding over Kyle Rittenhouse's trial unleashed a furious tirade against the lead prosecutor. The outburst came in response to the prosecutor's attempt to question Rittenhouse about his use of an AR-15 style rifle to protect property rather than human life. Defense attorney Mark Richards accused the prosecutor of intentionally provoking a mistrial by disregarding previous rulings. The judge, Bruce Schroeder, dismissed the jury and launched into a scolding of the prosecutor, admonishing him for suggesting that the court had left the door open for certain lines of questioning. In a raised voice, the judge made clear that his previous statement about leaving the door open was for himself, not the prosecutor. The tension in the courtroom was palpable as the judge berated the prosecutor for his actions.
Well, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
you should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not a motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
Their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
One of the issues that particularly incensed the judge was the prosecutor's reference to Rittenhouse's post-arrest silence. The judge expressed astonishment at the prosecutor's decision to bring up this topic, emphasizing that it had been a basic law in the country for decades not to comment on a defendant's silence after arrest. He questioned the prosecutor's motives and expressed his confusion over why such a basic legal principle would be disregarded. The prosecutor defended his actions by stating he had filed a motion to present evidence suggesting that Rittenhouse had expressed a desire to use his rifle to defend property rather than human life on a previous occasion. However, the judge shouted back, stating that even if the prosecutor was correct, he should have brought the matter to the court's attention beforehand.
It is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been going in.
The prosecutor argued that the defense had introduced evidence of Rittenhouse pointing a gun at a person on a car, indicating a lack of justification for such an action. He continued that he should be allowed to show that Rittenhouse's threatening words proved he had intentionally provoked the situation in Kenosha. Rather than acting in self-defense, the prosecutor believed that this line of questioning was relevant to Rittenhouse's state of mind and his intent. The judge, however, strongly disagreed, asserting that the defense theory centered around Joseph Rosenbaum, the first person Rittenhouse shot, making threats without the ability to carry them out. The judge rejected the prosecutor's argument that Rittenhouse's verbal threats on a previous occasion were relevant to the case, as Rittenhouse did not have his gun with him at that time. The prosecutor pointed out that the jury had already heard evidence of mere verbal threats being used as a basis for subsequent actions. He believed that Rittenhouse's previous statements about shooting shoplifters with his AR-15 should be used to impeach the defendant in the murder trial. The judge, visibly frustrated, reminded the prosecutor that the evidence he sought to introduce was excluded as propensity evidence under the Wisconsin Rule of Evidence. He argued that Rittenhouse's attitude of wanting to shoot people was not comparable to the incidents in the case, and that nothing in the trial had changed his previous rulings. The tense exchange between the judge and the prosecutor and continued with the judge asserting that there was no similarity between Rittenhouse's comments and the incidents in question. He dismissed the prosecutor's argument and instructed him to read more on evidence, all while praising the defense's lawyering.